With your permission, sir, we start the proceedings of this very important and significant webinar. This is the third webinar in the series of Legal Services Month, which we are celebrating, both CII and the Society of Indian Law Firms. I happen to chair these two organizations, that is the task force of CII Legal Services and Society of Indian Law Firms. So we are celebrating 20 years of Society of Indian Law Firms and 125 years of CII. So this is a great combination. So we, under guidance of Mr. Vikas Mohan, who is the Special Director of CII, both of us, we decided that we'll have a month-long celebration on different topics which are of interest to general CII membership. And CII, sir, as you know, that it is the apex body of business and industry leaders of this country. And this is the third webinar. The first one was on insolvency and bankruptcy code. The second one was on dispute resolution and streamlining ADR mechanism. I wish we had you there also, because you have done a lot of work, pioneering work in this field of alternate dispute resolution. At least I am personally aware of it. And today we have labor law reforms, and this will be followed by competition law, and then IT and ITES laws, intellectual property rights, and Companies Act and SEBI regulations, land law reforms, and finally the taxation law reform. This will be spread over the rest of the month of November. So it is my privilege to welcome Honorable Justice J.R. Midda to this webinar. We are very grateful to him for having taken out time. I know how the Honorable High Court judges are working these days. They sit till 5:30. Although they make us sit also. They make us sit also, but at the same time, they have to go through all the files, while we only have to look into one or two files in which we are appearing. And we have an excellent panel, which is being chaired by Alok Basin. He's the chairman of the subcommittee on labor laws of CII, a very eminent lawyer, a very eminent author, and well known, you see, throughout the country as an expert in this field. And then we have Mr. Anupam Malik. That is, he's a former bureaucrat, very responsible bureaucrat, former additional labor commissioner of Haryana. So it is a privilege to have him. And then we have a very, very distinguished counsel lawyer from Chandigarh, that is Punjab and Haryana High Court, Mr. Pawan Kumar Mutneja, a well-known figure in the field of law, both in Punjab and in Delhi and rest of the country. And we have Miss Ritika Ganju. She is partner of a very eminent law firm, Phoenix Legal, which is headed by Manjula Chawla. And Ritika is an integral part, a senior partner of that firm. And last but not the least, we have Mr. Amir Singh Pasrij. He is the founder and managing partner of International Law Affiliates. And Mr. Pasrij has a specialization in this field of labor laws, and he is recognized as a very eminent representative of India, even in the International Bar Association and other organizations. So it is my privilege to welcome all of you to this important seminar on labor law reforms. I only want to leave one thought with you, and because I don't want to take much time, there are many panelists here and we have to hear Justice Midda also. That thought is, and I'm leaving it with Alok, to, if possible, to have another webinar sometimes next month. that we have the new labor codes now, the 3 labor codes. What is of importance and significance is to see how the law, which is already in existence, the existing law, how that will be materially affected, because the labor law jurisprudence has developed, keeping in view, you see, the evolution of labor laws right from 1940s with the various acts coming into force and till recently. So that evolution, how will that be affected by this new code, labor code? Whether the decisions given by the Honorable Supreme Court and High Courts under the old laws, which are now being superseded by the new laws, will those still remain relevant? And if so, in what areas, in what respects? I think that we will be doing a great service, not only to the CII membership, but also I think to the country as a whole, if these could be highlighted as to the material changes which have been brought about and for which the old law may appear to be obsolete, but in certain areas it may not be. It may still be very relevant. So what I would suggest is that we should have another round after today's deliberations to discuss, you see, the impact on the jurisprudence of labor laws so far as the new laws are concerned. So this is one thing one thought which I leave it to you. And now I'll request Mr. Vikas Mohan to please formally welcome our panelists and particularly Honorable Justice J.R. Midha, Honorable Judge of Delhi High Court. One thing about Justice Midha is that he is not just a judge, he is a jurist judge. All judges are not jurists, and I say with some sense of responsibility. But Justice Midha is one of those distinguished judges who is also a jurist, he's got the scholarly background, and what he has given, you see, to the society in the form of his judgments, I think that is unprecedented. And very recently, say in the last 1 year, I saw 2-3 judgments which have a direct bearing on labor laws, you see, particularly in cases of loss of confidence or in the cases of alternate remedies available to people, they're rushing to the High Court and all that. So he's a very versatile figure, and we are indeed privileged to have him. Over to you, Vikas Mohan.
Thank you. Thank you, Chairman, sir. And good evening. And on behalf of CII, I welcome you all to this webinar on the labor law reforms. Honorable Justice J.R. Midha, Judge, Delhi High Court. Thank you very much, Your Lordship, for your time and kind presence. It is my privilege and honor to welcome you to this important session. Also grateful to Mr. Anupam Malik, former Additional Labour Commissioner, Haryana, and Mr. Pawan Mutneja, Advocate, Punjab and Haryana High Court. Of course, special thanks to Dr. Lalit Bhasin, Chairman, CII Task Force on Legal Services, and President itself for leading and guiding this important initiative, and to the members of the task force, Mr. Alok Bhasin, Chairman, CII Subcommittee on Labour Laws, who would be the moderator for today's session, Mr. Amir Singh Pasrich, Founder and Managing Partner, International Law Affiliates, and Ms.
Dr. Bhasin, would you like to take over? I think that he's dropped off.
I think I would. There seems to be some problem. Can you hear me, everyone?
Yes, Mr. Bhasin, we can.
I'm
Dr. Bhasin, we can hear.
So now I would request our honorable chief guest, Justice J.R. Midda, to please deliver his inaugural address of this webinar. Over to you, Honorable Justice Midda.
Yes. Dear respected Dr. Lalit Bhasin, Mr. Amir Pasrich, Mr. Vikas Mohan, Director of CII, Mr. Alok Bhasin, and other respectable panelists and the audience. I'm thankful to CII and Society of Indian Law Firms to invite me on this occasion to speak on recent labor reforms. You see, I compliment both the organizations to choose a very prominent time to discuss on the labor reforms which has recently been enacted and the draft rules are still in the consultation process. In fact, the discussion at this relevant time is very important as the awareness of these laws will also give an opportunity to the people to submit their views and suggestions and also their objections or whatever further additions they feel can be done in the draft rules to make the laws better and more perfect. You see, as all of you might be aware, we had approximately 40 central acts and about 100 state acts, which are from the period 1940 onwards, which has resulted in multiplicity of the enactments, authorities, as well as the inconsistent and contradictory definitions, which resulted in a lot of confusion, as well as the ratings of our country in ease of doing business had come down very substantially, and the investors and foreign investors, they were very reluctant to come and invest the money in the Indian industry to build up the economy. You see, labor falls in concurrent list of the Constitution, and in 1999 a second labor commission was set up by the government, and that labor commission recommended that there are too many labor laws and they need to be consolidated, and 4 codes should be enacted which should deal with all the laws, and the labor laws need to be simplified, and the labor rights and labor rights should be balanced, and the multiplicity of the authorities should also be removed, and there should be simple authorities to look into the subject. So on the basis of the Law Commission report, 4 codes have been enacted. Code of Wages was enacted in 2019, whereas the 3 codes relating to occupational safety, health, working conditions, social security, and industrial relations were enacted this year in 2020. The acts have not yet been implemented, and since the draft rules are still in the consultation process. You see, the object behind bringing these codes is to simplify the process, remove inconsistent definitions, ease of compliance, uniformity, multiplicity, growth, and to strengthen the enforcement. You see, the details of this, I'm not going into the details of these 4 codes. We have got a very expert panel of speakers who will go into this aspect. But I will highlight few issues which the panelists and also the audience will consider, which have not been dealt with, and you will consider whether something can be done in the rules or not. You see, while dealing with many cases before Delhi High Court, we came across the enforcement procedure. You see, the awards of the labor courts, they are enforced by the SDMs as the areas of land revenue. And when we called for the records, we noticed that the SDMs do not conduct the courts in an open court system. No dates are given. And the litigants keep on making inquiries and they are told that we are not aware what is happening. No dates are given. And if any of the parties manages these things there, the case keep on lingering for years together, decades together. So then in one of the cases, the Delhi High Court, the judgment given, the directions were given that henceforth the SDM will hold the court in an open court. Cause list will be displayed. Matter will be taken up in the open court. Orders passed will be uploaded. And then there was no set procedure for, let's assume it is a recovery of money. There's no set procedure for effecting the recovery except issuing notice, and the person doesn't come, then keep on issuing notice again and again. Then the Delhi High Court in one of the judgments of Bhandari engineers laid down the guidelines for execution of the decree and awards, and these directions require the judgment debtor or the respondent to disclose all his assets, income and expenditure in a prescribed format under Order 21 Rule 41(2) of the Code of Civil Procedure, and as well as the affidavit in Form 16A of the Code of Civil Procedure. And as per Order 21 Rule 41(2), if the affidavit is not filed within 30 days, then the person can also be detained for up to a period of 3 months. So SDM was directed that on the very first date when the execution case is listed, they will direct the respondent to file the affidavit of his assets, income and expenditure in the format prescribed in Bhandari engineers. And the endeavor should be made to dispose of the case within a period of 6 months at maximum outer limit of 1 year. So these guidelines have been implemented in Delhi. With the result, all execution cases are being expedited. Litigants are become aware. Courts are being held in open court system. Dates are being given, and the order is being uploaded on the website. But now, even in these 4 codes which have come into play, I do not see any provision which deals with the execution process. You see, execution is a more difficult area. And you see, a person keeps on litigating first before tribunal, then matter goes to the High Court, then matter goes to Supreme Court. After the litigation is over, after a long time, if still we don't enforce it and we do not simplify and make a mechanism in which the ultimate litigant who has succeeded gets the reward, to my mind, the complete justice is not done. So I was wondering whether this although the acts do not, all the codes do not contain the enforcement procedure. And if some speaker feels it is there or has a different view, we can discuss it in this discussion. But we should also consider whether something can be done in the rules to make the procedure of enforcement a time-bound manner in which the litigant gets the fruits of the award, which is ultimately passed by the industrial tribunal or the labor court. So this is one area which I thought I should highlight, which is not part of the code, and in which the audience here would find an interest. Second area which I also want to highlight is that while dealing with the cases of employees' compensation in Delhi, we noticed that the employees' compensation cases are adjudicated by the labor officers. And under the Employees Compensation Act, and I understand that the provisions relating to employees' compensation have not found major change in the new code. In the new code also, the amount which is being computed is almost the same which is there under the Employees Compensation Act. And that amount, I am of the view that amount requires revision. You see, for example, a person, a construction worker who suffers an accident during the course of construction arising out of his employment, and he suffers fatal injuries and dies, the compensation amount is in the range of about 10 lakhs or so according to the wages. Same table is at present also. But if we see the other compensation laws where no fault liability is also no fault liabilities concept is there, the amounts are at variance. In one of the cases, the Delhi High Court is examining whether there should be a uniform compensation law. A person who suffers with a death or injury in employees' compensation gets a different amount. Person who suffers a road accident, no fault liability is a different amount. If he suffers in some other area, he gets a different amount, whereas the value of human life should be uniform. That is one area in which, again, there is a need for deliberation. That apart, one more point which requires consideration is that against the award of the under the Employees Compensation Act, the first appeal is provided to the High Court on a substantial question of law only. Whereas and mostly in all the statutes where the first appeal is restricted only on a pure question of law, there the cases are adjudicated by a judicial officer at the stage one. So in one of the rather two judgments of Delhi High Court recommended to Delhi government that look, since the order of the Commissioner of Employees Compensation is open to challenge only under the first appeal to the High Court, therefore these courts should be manned by the judicial officers, and this jurisdiction should be transferred to the judicial officers, which was not agreeable to the government. But similar provisions are continuing here also. So that is one area which again requires deliberation and consideration. And I am of the view that CII as well as Society of Indian Law Firms, after deliberating upon what is the outcome of today's webinar, they should form a committee to look into the draft rules, and whatever suggestions are there should be given to the competent authorities at this stage only, so that whatever can be done to make the rules a very comprehensive and perfect, and because this is a new, many of the provisions are new in this, where there are no judicial pronouncements as on date. So all these provisions will have to be time tested in the coming time. So therefore, if some committee is set up which looks into and makes deliberations and suggestions would be a good move. So I am not going to detail into the all 4 codes. We have got very expert panelists who will put light on their and give their expert opinion. And since we have a restricted time frame and I was told to restrict to 15 minutes, so I would not take more time and I'll leave the floor open for discussion by the panelists. Thank you very much.
Thank you, Honorable. Thank you, Honorable. Thank you very much for your very valuable inputs and your suggestions, particularly with regard to enforcement of codes and no provision in new codes regarding execution. And then, also you rightly pointed out about employees' compensation, that the most significant aspect of your thought was value of human life should be uniform, you see. I think that's a very valuable input. Yes, and what you have said is that these should be made known, you see, to the authorities that be. That is the entire idea of these webinars that we are having, that after the deliberations of this webinar, then the panelists, whatever their views are, there will be a report prepared which will be submitted to the top leadership of CII, including the president, Mr. Uday Kotak, and through him, these will be routed to the appropriate departments of the government, that is the Ministry of Labor and all that. So, and this is the right time, as you rightly pointed out, to make some suggestions, because from 1st April, when the rules are in place, these will be implemented. So we still have time, you see, to suggest in the subordinate legislation, if that is permissible, that you please incorporate these features, which very rightly you have pointed out. Again, sir, very grateful to you for your presence and for your address. And now to the chairman of the webinar, the moderator also, Mr. Alok Basin.
Can you hear me? Yeah. I think, yes. Honorable Justice J.R. Midha, Dr. Lalit Bhasin, Mr. Anupam Malik, Mr. Pawan Mutneja, Mr. Amir Singh, and Ms. Ritika Ganju, and of course, Mr. Vikas Mohan. Mr. Vikas Mohan, may I request you to please share my presentation, please? Yes. Now, you can just quickly, proceed further. As also observed by Honorable Justice Midha, that the genesis of the 4 labor codes lies in the recommendations of the Second National Commission on Labor, which the Government of India had set up to suggest rationalization of existing laws relating to labor in the organized sector and an umbrella legislation for ensuring a minimum level of protection to the workers in the unorganized sector. Next, please. Now, having reviewed the entire gamut of labor laws, the Commission recommended that the provisions of the then existing labor laws should be incorporated in a comprehensive code. As a first step, the Commission recommended that the labor laws be grouped into well-recognized functional groups relating to industrial relations, wages, social security, and safety and welfare. Now, in pursuance to the recommendations made by the Commission and the deliberations which the stakeholders held, the central government decided to rationalize and amalgamate different central labor enactments into 4 codes. Now, these are the Code on Wages, the IR Code, the Social Security Code, and Occupational Safety, Health and Working Conditions Code. Now, the Code on Wages amends and consolidates the laws relating to Equal Remuneration Act, the Minimum Wages Act, the Payment of Wages Act, and the Payment of Bonus Act. Now, this received the assent of the President on 8th of August 2019. Final rules have not been notified so far. On the Code of Wages coming to force, these 4 acts, they shall stand repealed. And you see, this Code on Wages has created, sets up a new wage regime, and our friend Mr. Pavan Mutneja would be focusing on the new wage regime, which these different codes have set up. Next slide, please. Now, the Industrial Relations Code amends and consolidates the laws relating to trade unions, conditions of employment, and investigation and settlement of industrial disputes, namely the Trade Unions Act, the Industrial Employment Standing Orders Act, and the Industrial Disputes Act. Now, this received the assent of the President on 28th of September 2020. Draft rules were notified on 29th of October 2020. Next, please. This IR code provides for a new feature of recognition of negotiating union and negotiating council in an industrial establishment by an employer for the purpose of negotiations. Next, please. The criterion for recognition of negotiating union has been fixed at 51% or more workers on the muster roll of the establishment. And as regards negotiating council, a trade union having support of every 20% of workers will get 1 seat. Next, please. Now, till now, there is no central legislation regarding recognition of trade unions. Now, for the first time, there will be a central enactment in this regard. Next, please. So it is hoped that the new provisions would lead the way in creation of a robust system of collective bargaining and harmonious industrial relations in the country. However, much would depend on the attitudes adopted by the social partners. Next, please. Now, then standing orders. Now you see there is some change in standing orders. The Standing Orders Act applies to 100 workers, and now this will apply to 300 workers. Next, please. Now the central government will make the model standing orders, unlike the present act where the appropriate government makes the model standing orders. Next, please. Yeah, you can just flip through. Yeah, please proceed further. Yeah. Now, the Industrial Relations Code replaces the sexist term workmen by the gender-neutral term worker. The definition of worker includes persons employed in supervisory capacity, getting wages up to rupees 18,000, as well as working journalists and sales promotion employees. Next, please. Now specifically the industry, it excludes the charitable, social, or philanthropic services. Next, please. Now, concerted casual leave by 50% or more is also strike. Next, please. You can just flip through because time is short. Now, you see, for the first time, fixed term employment has been formalized, and Mr. Anupam Malik would be focusing on this new regime of fixed term employment. Yeah, next, please. You can just keep on proceeding because time is little. Just, yeah. The reference system is removed now. There is a time frame of 2 years for conciliation. If dispute is not settled in conciliation, any party can directly file an application before the industrial tribunal. Now, there will be no labor court, no board of conciliation, no court of inquiry. there will be only Industrial Tribunal and National Industrial Tribunal, and Industrial Tribunal will be manned by a judicial member and an administrative member. Yes, next. Now you see, for factories, mines, and plantations, if the workers are less than 300, then no need for prior permission for layoff, retrenchment, and closure. Next, please. Then the reskilling fund and all for retrenched workers. Then there's a provision for exemption of any new industrial establishment for in public interest. Civil courts are barred. Yeah, next, please. Then Code on Social Security. Next, please. It amalgamates these 9 enactments: employees' compensation, ESI, PF, and so forth. And now gratuity for fixed term employment, even if he has rendered 1 year, he'll be entitled to gratuity. For working journalists, it is 3 years. Yeah, next, please. And this is a very new feature that now the government has to make schemes for unorganized workers, gig workers, and platform workers. Very welcome feature. Then the last code. Next, please. This amalgamates 13 enactments. Yes. So now I would request. Yeah, that's all. Thank you. Yeah, could you please? Yeah. Now I will request Mr. Anupam Malik, former Additional Labour Commissioner, Haryana, who was also member of the drafting committee of these 4 codes, to give his presentation on this. Particularly, I think he will focus on fixed term employment and how this new regime encourages responsible collective bargaining, and of course it aims at providing flexibility by providing this fixed term employment to the employers. Over to Mr. Anupam Malik, please.
Sir, you are on mute, please, sir. You have to unmute, please.
I think the I'm on side, not my side. Even on the controller.
We can hear you now, sir. Please proceed.
Okay. Because mute. Okay. Honorable Justice, respected Mr. Bhasin, luminary viewers, it's indeed an honor to be in this to share my views. Of course, as an administrator of labor laws for 35, and now I am into an independent man. With all my experience, each one of has a experience. I'll come directly to the topic. Codes on labor laws have brought about consolidation and consonance of concept. The laws, the employees and employers, conjunction of operational aspects for simplification of compliance for the employer, the employees, and the enforcement machinery, of course. That's very important. Then we missed out somewhere. You did mention has given a very quick view of things which have come in. practically the Working Journalist Act and the Promotion Act, Sales Promotion Employees Act flows practically because they've been included in the definition of worker. Slightly sideways have been at different times come to the needs of those times, but it is also basic employment rights of the workers, but and to sabotage the textile area, which the British industry miserably failed to create. So is the case. But and employee hitherto dependent on sort of case law and litigation on the two words and distinction between them. Structured definition of industry, then the institutions have been excluded, philanthropy have been that the honorable courts certificate. Yes, let me tell you the magic number is 300 because the largest are within the 300 bracket of number of workers, and even beyond. If there are industries which are larger, and they simply say we have the government need not interfere, and that 200 rupees penalty and those inspectors visiting, all that is over. Promotion of bipartite mechanism will dominate. This is a very big issue which has been totally absent in the previous law. Time limit for raising dispute has been clarified because we were again dependent on case law. Clarity and structure and functional procedure of tribunals. Honorable Justice Minta had pointed out there is a what kind of adjudication and what is the implementation. Now these tribunals have become very powerful, they are very structured, and judicial officers are for functionality. In my 35 years of experience, I have seen only 2 cases of arbitration, and that also failed. Worker reskilling fund to be constituted, it is still a far cry because the concept is not clear. It is focused on the future needs. Let us be very clear. That is about change. Change is the only constant, and the future changes are going to be, again, we do not know. Then for the trade unions and registration more clearly defined as per the latest case law from the APES court. Discourage roadside unions. Blackmailers and the street urchins they wouldn't be calling them trade unions themselves trade unions. No blackmailing, no disagreement. You cannot be compelled to contribute. But I am pointing out very critical, which have been a very bad pain for the industry. New concept of negotiating union or negotiating council is the most wonderful thing that has happened, and it is, of course, and tripartite. The minimum number of workers of industry are members. You have to have 10%. Recognition of trade union, again, state level. See, let me define this. This status responsibility. Once you acquire status, you have to carry the responsibility also. And very important focus this is the hallmark. Earlier, bipartisan was a choice. non-starter, it never exists. Units, works committees, and that also not functional in the private. Though introduced, if you go out, you can't take any number of years to raise a dispute. New concept of negotiating union, negotiating council. Now this again entails responsibility, and they will have to responsibly take up cases in bipartisan. Okay, you want to go on strike, you cannot. The notice will not remain in perpetuity. The notice has to be followed up within 60 days. The threat, the blackmailing will not continue. It has to be meaningful, structured, and rational. No blackmailing anymore. Wide definition of strike. 50% of workers consulted. Courts have ruled so many times that dharna, demonstration, disruption, it all is more damaging than a full-fledged strike. Now, here is for the first time you have defined strike exactly what it means practically. So, see, the parties are being forced to fall in line. Because cases of come down heavily on conciliators, officers sitting over cases of disputes for years. I mean, the law has been kept into the courts. Now cannot. The conciliation officer before him, he had to the government. Yes, it was a you see, report part of our working. In Haryana, we have been, but now it is part of the structure of the law and answerable. And provisions converge to insist upon responsible collective bargaining. You see, people, the parties, the social partners, they are compelled. First of all, you can't have outsiders just poking in for any other reason than the purpose of the. And the parties to the dispute or grievance, they will have to first of all resolve the matters at a grievance level. That is about promoting bipartisan, which is most important. And collective bargaining has its very first level of resolving and grievances, and then settling, even if there are disputes, settling them mutually. And the third party, the government, comes in much later. So the new structure which has been brought into a mandate is going to promote bipartisan in a very big way. Okay, the other issue focus on is very interesting. The very specific areas have acquired a totally new dimension is defining of non-core functions for contract claim and no provision for contract in core deployment in core functions. Even everybody, some officer in the government contract is exposed. He is to judicial scrutiny. Right now, everything was behind the scene. Now it cannot happen. Why? Because 6% of the employment labor and the unions, the registered unions, no more. But the procedure for registration and license under the Code of Occupational Safety. Now again, it is split. The non-core areas are defined in the higher code, but the issuing licenses in the Code of Occupational Safety. Provision for fixed term employment is most interesting. On one side, you block the contract labor. On the other side, you have the fixed term. You see, you are facilitating. Look at the broader picture. People have been talking about hire and fire. What do you mean by hire and fire? Fire a person who does not compromise his rights. Hire and dubious kind of call by the employers. Now it is defined. What is hire and fire? Why do you need to hire a person? Why do you need to fire a person? off. There is a closure of an establishment. What is firing? What is hiring? You can have a fixed term employment. The government, please be sure, is on industrial growth and employment. No, something which is not, please note my words, which is not specified here in the law. Fixed term employment does not mean an open invitation that you keep on employing people for any number of years. Again, every year, for 10 years, every year, yearly contracts, because mind you, the chapter on unfair labor practice is intact. And the judgments of the Honorable Supreme Court are on the same view. And the Schedule 5 is now Schedule 2.10. Schedule 2 says engaging people for years together to deprive them of years of... but here is the case where the fixed term employment terms. On 1 year service, the fixed term employees get gratuity also, and equal wages and social security and everything. So there goes the... Under the latest, let me connect. They have 2 years after 2020, if you are engaging workers, you will be provided a subsidy on, that means 12.5% employer's liability and 12.5% liability will be borne by the PF for the next 2 years. The government is inviting people to hire on fixed term for 2 years and you get 25% subsidy. Is it not interesting? You're not looking. Please link all these things together. And on better terms, that means the facility is being provided to the industry to work, progress, but with social justice, not exploitation, not at the cost of worker. But in the real sense, industry is employing less than 300 workers do not need the permission of the government for layoff, retrenchment and closure. We had, in fact, quite a few of these provisions we had already implemented in Haryana. Because there was some delay here and I was asked, okay, go ahead in Haryana. So many states went, 5-6 states had already provided this. The earlier, if less than 100 workers are there, you don't need the permission of the government of arrangement and closure. Why? Everybody is asking me why. See, restructuring was the hallmark. Your industry and growth is very strongly on exports. And exports and technology are two criteria which create uncertainty. You see, you do not know what is going to be there the next 6 months or the next year. If you do not allow the industry to restructure as and when they want, as per of technicalities or the market or your buyers abroad, you are stifling them. Now here is the law which not only provides a rational restructuring but also says, okay, I will give you also. The government says for 2 years, if you employ people, they borne by the employer share and the employee share will be borne by the government. Don't you think it is the largest? How can anywhere in the government, anywhere in the world? I mean, just look at the comparison that the government is seriously laying a red carpet for the industry, that you employ people, run your business, grow, develop, and restructure as and when you want, but not at the cost of the rights of the worker. Don't exploit them. Don't pay less than minimum wage. Mr. Mutteja will explain how tough is the wage code. In fact, my involvement in the wage code was much more. But here is a case where I need to explain that fixed term employment is actually on better terms of conditions than conditions of permanent employees. So it is going to be a big boon. But be sure that anybody stepping out and trying to use it as unfair means is going to be in trouble again, because there is sufficient case law from the apex court, the higher courts above, which will come down heavily if these provisions are misused, abused for unfair labor practice. I'm sure I've explained myself. So to conclude, that the Code on Industrial Relations would actually ensure affirmative administration of the law and industrial peace that cannot be hostage to the whims of any party to it, much less political. Unions cannot anymore have a free hand at politics. You have to focus in your membership, in your structure, in your working, devoted to the industry. And if you have political agenda, you have to have a separate fund in which a first worker cannot be forced to pay. Then promotion of primary mechanism for maintaining industrial harmony was a hallmark. Strong and better defined structure and function of authorities and the code for effective implementation. The moment you give a defined structure and a status, and with that always comes responsibility, and anybody not complying, obviously they're going to be in trouble. The courts are there. We've had a wonderful judiciary over the years. They've done a wonderful play. In fact, the entire labor laws, the gamut of labor laws has been evolved and developed by the, because these laws which were prior to 1947 were all meaningless. Mr. Muteja will explain that payment of wages was meant only to serve the British the railways and the structuring, the constructions. That's all. Where was the orientation to the industry? Nowhere. Provision of flexible HR structuring now would be a great facility, and private exploitation, especially, has been a bad part. Believe me, 60% of the employment in private sector, even now in the government, has been contract labor, which has been widely exploited. Their social security money has gone off. They have not been paid. Their leave, their working hours, all totally in a very, very bad state. Provisions provide flexible working in tune with the emerging industry scenario. As I said, the hierarch is affirmative administration, then the bipartisan, and lastly, the flexible working is very much futuristic and it will harm economic development, and it shall be ensured by us all. I am sure we all are longing for industrial growth. It's not only our Honorable Prime Minister. We are all longing for industrial peace, growth and development and progress in the country. Important provision. See, thank you. God bless India. Over to did I take more time or less time?
Yes, I'm audible now.
Yes,
believe.
yes, please. Yes, please.
Yes. So thank you, Mr. Malik. I would now request.
I'm in time.
Yes. I would now request Mr. Pawan Kumar Mutneja to sum up his views on the new wage regime within 10 minutes, please. Thank you very much.
Can I have my presentation, please? Mr. Justice Midda, Mr. Bhasin, members of the panel, ladies and gentlemen. The new wage regime under the Labor Code provides a paradigm. The Code of Wages 2019 provides a paradigm shift in the orientation and implementation of labor laws in the country. The new wage takes care of 4 different acts: the Payment of Wages Act, the Minimum Wages Act, Payment of Bonus Act, and Equal Remunerations Act. Next, please. What is why the Code on Wages? What is the most simplest definition of relationship of employer and employee? That is, job done, wages paid. But if job is done, are the wages secured and protected? This is all about the Code on Wages. Next, please. Article 38 of the Constitution seeks to protect social order, economic and political. But the Payment of Wages Act applied to limited industries, and there was a cap on Payment of Wages Act. It did not cater to the masses. Article 39D provided for equal pay for equal work, but Equal Remunerations Act did not give the correct orientation. Next, please. Article 43 seeks to provide a living wage for workers. A living wage is one where the needs of the workers are catered to and he has time for leisure. But this remains a utopian concept. We are still struggling at minimum wage level. The casualty in all this was Article 21, which provides for a right of life and liberty. Next, please. Now, the applicability of the Code on Wages Act will be evident by a few definitions. First is establishment. Any place where any industry, trade, business, manufacture, or occupation is carried on and includes a government establishment. This is the widest possible definition. Now we come to employer next. Is a person who employs directly either through any person on his behalf or on others' behalf, one or more persons in his establishment, and includes contractor and includes legal representative of the deceased employer. What has changed in the new law? The definition, definition of employee and as compared to worker. Earlier, it was limited to workmen in various acts, but here employee includes every worker except an apprentice or a person in the armed forces. This is in contradiction to worker, where both apprentice, army, air force, and navy act, as also people under the police and administrators, managers, and supervisors drawing wages in excess of rupees 15,000 are excluded. The Act deals primarily with employees, except in some portions of the Minimum Wages Act. Next, please. The fulcrum of our talk is the new definition of wages. Wages are all remunerations, whether by way of salary, allowances, or otherwise, expressed in terms of nominal of being so expressed, which would, if the terms of employment express of employed were fulfilled, and payable to a person employed in respect of his employment or work done. Such employment includes basic pay, dearness allowance, retaining allowance. I stop here for a minute. That if all remunerations are included, then why should they add basic wages and DA? The reason being that what has now changed in this law? That is, that is an inclusive portion, the first part. The second part is an excluded portion, wherein 11 exclusions have been provided. Now, if the excluded portion exceeds 50%, to the extent or it exceeds 50%, it will be added in wages. So therefore, if the inclusive portion, for example, is less than the minimum wages, it will have to be increased to go to the minimum wages. It seems very complicated, but if effectively it is not. The wages provides a check and balances to ensure a fair wage to the worker, to the employee, sorry. It also gives a stern message to oversmart employers who seek to cut wages by skirting the law, as also laggards who refuse to comply by the law. It mandates obedience of the law. It also gives a message to the HR department to follow the law rather than blindly go by the diktats of the audit department. The HR personnel should remember the days of herd hiring are over. HR teams will have to structure their recruitment to watch the economic value addition of your business. Next, please. Now we come to the specific acts which have been incorporated in this act. The Payment of Wages Act provides for fixation of a wage period, uniform timeline for payment of wages, deductions, and fines. Now, uniform timelines have been provided with regard to daily wages, who will have to be paid at the end of the day, weekly wages at the end of the week, the fortnightly after the second day of the end of the fortnight, and monthly wage next. It also provides for resignation, retrenchment, and employees affected by closure. They will have to be paid within 2 days. And it also, now we come to the Equal Remunerations Act. Equal Remuneration Act provides for gender neutrality in the payment of, and operates in two fields. One is the payment of wages, and second in recruitment. For same and similar work, you cannot discriminate amongst members of various genders. That includes men, women, and transgender. And similar work has been defined to have work which has the same skill, effort, experience, and responsibility. Next, please. Next. That brings us to the minimum wages. Minimum wages was basically a play between basic wage and cost of living index. Now, two different considerations have been provided. That is geographical and arduousness of work affected by temperatures, humidity, and work being performed underground. A new concept has been introduced, that is the national floor wage, or that is the national minimum wage. Now, this is to be fixed by the central government in consultation with the state governments and with assistance of the state, with the Central Welfare Board, Central Advisory Board. Can you give the last, please? State governments are entitled to have their respective minimum wages, but that cannot be less than the central minimum wage. Next, please. Next, we come to the Payment of Bonus Act. No employee has been excluded, but payment of bonus has been provided for industries employing minimum 20 people. The bonus has to be paid within 8 months by crediting in the bank accounts of the employees. It has to be paid by the employer in whose establishment the employee works, including contractor, and wage for the purpose of bonus applicable is minimum wage. Next. Now we come to the most interesting part of the presentation of this act, that is inspectors. Inspectors were always the eyes and ears of the department, but now they've been given a mouth too. They have been called inspectors cum facilitators. First and foremost, they have a job to advise the employer on what is the law and how it should be complied. In case the employer does not comply with it, a warning will be given. If he still does not comply, then come in fines which are very, very exorbitant. And in case after the first contravention, he still does not comply with the law within a period of 5 years, he could be punished and even put behind bars. Next, please. The offenses and penalties, as is evident, become drastic. And with regard to now, a complaint can be made by the trade unions, by the employees, or by the appropriate government. Next. Now, the effect of wages on social security benefits of other laws. Provident fund contribution is 10% of the wages, which is to be payable. Pension is of course cut from the employer's contribution, which is up to 8.33% of the wages. Insurance schemes is 1% of the wages. Employee state insurance, this still has to come out in the rules or regulations. And gratuity is 15 days of wages for each completed year of service, based on rate of wages last drawn by the employee. Now, in conclusion, the Act provides for the unorganized sector also, and extends to domestic servants of the employer. That means if the employer has numerous employees who are employing drivers, all those will come in. And if the drivers are more than 5, then their records will have to be kept, which can be inspected by the inspector at places. Summing up, it's a great law, but it requires application. Thank you.
Mr. Basin, you are on mute, please.
Hello?
Mr. Alok Basin, you are on mute, please.
Okay, thank you. I would now request Mr. Amir Singh to briefly discuss on the changes in the contract labor regime under the new codes. Thank you, Mr. Singh. Over to you.
Yeah, he's Mr. Amir Singh Pasreech.
Yeah, yes.
Yeah, we call him Amir.
Dr. Basin is very kind. Thank you, Dr. Basin. My name is so long that it doesn't fit in the window. Yes, can you see the slide? And am I audible?
Yes.
Yes, please.
Excellent, thank you. Would you move to the next slide, please? Yes, thank you. So I wanted to bring out just a couple of points about this transition. Going back to 1999, it has its roots in the Vajpayee government, and Prime Minister Vajpayee's government had these 4 codes proposed as far back as that. I think a lot of work has gone into this since then, and there's been a select committee. If you go to the next slide, please, you will find that there has been a tremendous amount of effort put into this. So what are they trying to do? This is what they propose, what the government states it is doing. Common and uniform definitions, avoiding multiple authorities, transparency and accountability, reduce compliance, licensing, discussion, and inspector-driven compliance. This is what I see them trying to achieve. One second, just stay back on that slide, please. Just go back to that slide, please. Now, I just want to point out to you that transparency and accountability is being introduced by online applications and some new features that have come in and are clearly recent. There are newer single window authorities. That is correct. And if you look at the bottom of this slide, you'll find reduced compliance, less licensing. I think, if I'm a little bit optimistic, that this is correct. The way they're structured, this is likely to happen. And I'll tell you why as we go along. Go to the next slide, please. Now, here are the 4 new codes. I put them on one slide only to show you wages, industrial relations, code on social security, and my brief is to speak on number 4, the occupational safety, health, and working conditions code. That is a very long name. I don't always remember it. I hope you can. But we'll call it the Occupational Safety Code for today. Could you go to the next slide, please? Now, if you look at these these codes, you'll find that the wage code replaces 4 acts. Go to the next slide, please. The Industrial Relations Code replaces 3 acts. And it's very important to just appreciate how this is happening. They have created an entire underlying scheme, and it does do a fairly good job of keeping an independent statute that is unified by purpose. Now go to the next slide. You can see the trend is there in the next slide, please. The Code on Social Security has all these acts. If you can see them on the slide, you'll notice that the purpose is manifest. There is an overdue need for bringing things together, which has been done. And from that point of view, the consolidation is a good thing. Now, come to the last one, please. Next slide. Now, in this slide, you will notice the number of statutes that have been put together. In this, no, I'm still on that slide. Please don't shift. And the next one, please. The next one, please. Yes, just stop here. So we have a series of new provisions and some well compressed. I will be talking about Clara. you will see it as the Contract Labor Regulation and Abolition Act. It's about 5 or 6 acts down on the left. But before we move to the next slide, please notice there are laws here that you may never have heard of. The Interstate Migrant Workers Act of 1979. And did you know that it applies to anyone having just 5 migrant workers? So it was very easily triggered, and it had a lot of beneficial provisions, but those have now been amalgamated within the Occupational Safety, Health and Working Conditions Code. Now go to the next slide, please. Now, when does this code apply? I'm sorry that I won't be covering the whole code, though I would have loved to, but I think Mr. Alok Bhasin will switch off my video if I do. So we have to look at focus, and the purpose of my presentation today is to show you a microcosm of what has been done. And I have, unlike the other speakers, I have actually taken sections and coded and compared them to show you what is going on here. Now, if you look at on the left of the slide, you find CLARA 1970, and on the right, you find the new code. And see and notice what is going on here. CLARA covered 20 or less people, and you were exempt. Now, the code says that up to 50, you're exempt. So smaller businesses, smaller contractors with up to 49 people will suddenly get that freedom that might have been necessary to unshackle them from being limited by 20. And I think in the smaller level of employment, this is a very good development. Everything is not good, but this one is. Please go to the next slide. Now, if you look at this slide, you will notice that we are talking about 20 workmen, and the explanations are all the same. So there's no change. It's the same old wine in a new bottle, but please go to the next slide. Now, the consequences are important. The consequences, which I want to highlight for the reason of my personal experience, are that the provisions of the CLARA were misused. I have been in a criminal proceeding defending a rather large company for having taken on more than 20 employees, because on one day their muster roll showed 27 employees in some register that happened to have been pulled out by a labor enforcement officer. Now, as you can guess, and they did not satisfy his purpose. So he initiated proceedings, which are now a reported judgment. Now, if you look at the consequences of that, I think that is going to happen much less with this change. And that is why it's written at the bottom, LEO has less power. I'll explain that as we go along. Please go to the next slide. Now, under the CLARA, on the left, you'll find there is also a new provision which was not there in the CLARA, which is on the right side, which is that although something may be contract labor and it includes interstate migrant workers, but it also excludes workers other than a part-time worker who is regularly employed by a contractor, meaning he's getting all the benefits of full-time employment. Say he's working for a well-known contract labor provider like Group 4, and he's getting, a PF, and he's getting everything else. Then actually he does not count as contract labor within that definition. So those are progressive changes, provided you can demonstrate that they are keeping within the law and are covered. Please go to the next slide. Now, if you look at the one on the left, you will also find in the old Act, there was this dichotomy, and I think we discussed it with Justice Midha earlier this week, where a person could claim to be a supervisor even though he was earning less than 18,000. That has changed. So that's there's a good threshold, but I'm afraid it does not apply to managerial or administrative, which excuse is still available and is still a bone of contention and can go to court. Go to the next slide, please. Now, as we've said, I've already mentioned that 18,000 threshold has been introduced, but there's something new, which is a matter of policy, which I notice in all these statutes. You might recall that the Gratuity Act was amended not so long ago, I think it was 2019, to raise the threshold to 10 lakhs. And it also said such number as will be revised by the government from time to time. I'm not sure about the exact language, but it's roughly that. So the consequence of that change is the government now has the power to revise something by notification without going back to Parliament or without laying rules on the table. So what I'm submitting is that there is an underlying theme in these codes which allows the government more powers to revise, issue new rules, and to fill up lacunae. This is one of them. Next one, please. Now, if you look at this slide, we're talking about that famous provision which underscores the CLARA. It talked about if you don't have registration, you're in trouble. Now, here I find that there has been a major change. Firstly, you're covered by a common license under Section 119 of the Occupational Safety, etc. Act, the code. And the second benefit is that the ban that was there, please go to the next slide, I'll show you. Go to the next slide. Yes. Now, the ban that used to be there in the Act, it was, don't forget the name of that law was the Contract Labor Regulation and Abolition Act. Now, the Contract Labor Regulation and Abolition Act has ceded to a code. I'm afraid we're going ahead of me. Can you go back a bit? Can you go back a bit? Sorry, can you go back one slide back? Thank you. Yes, so if you notice from here, the compliance has become much easier. Licensing is easier, but go to the next slide and you'll find my point is that, sorry, can you go to the next slide, please? Thank you. And just stop here. So Section 10 of CLARA covered prohibition. And the word used was prohibition. The act was called prohibition and regulation. Now, this seems to have changed. And I think the change is salutary because when you no longer insist on prohibiting it, you are enabling it. Now, go to the next slide, please. And you'll find that we have developed something new, which Mr. Anupam had talked about, and that was the core activity. Now, I did find that there is some jurisprudence on this from the past, but it's in another law. This core activity is now defined in the code, and there's also an escape hatch. So you can, if you're getting contract labor, you are banned from getting it technically in the core activity. But look at the three things on your screen and you'll find that there are 3 escape hatches. Now go to the next slide, please. Next slide, please. Now, this is what the core activity is defined to mean. So I took the escape hatches first so that I could show you what this act is doing is that certain things can be considered non-core activities automatically. Sanitation, watch and ward, canteen, as long as that's not your primary business. If your business is to run a hospital, then subclause 5 will not apply. In the nature of support services, so those are not core activities. Now, the benefit of that is that almost everything is permitted to contract labor as long as it doesn't form the part of your core activities. And then those 3 escape hatches that I mentioned in the previous slide, those protect you also. Can you go to the next slide, please? So now here's the fun. When you look at the CLARA, you find the state and the central government had powers to arbitrarily ban certain types of contract labor. And they did so, I'm sorry, but they did so not always without political purpose. They didn't do so only as a matter of reform. They did it because there were certain pressure groups on them. If you look at the notifications, there were some, I've seen them myself, and from 1975 to about 2012, the notifications reflect no consistency. Now, the good part is that this law establishes the possibility of core activities and defines them so that there's a thread running through. You are banned from outsourcing core activities, and there are 3 exceptions, and there are certain that will not be counted. Could you go to the next slide, please? And now, why is there doubt? Well, 57(2)(a) still allows the concerned government to see whether it's a core activity or not. Go to the next slide, please. So what has been achieved by this transaction? This is what I mean. In my opinion, there's a laudable move of the statutory regime from licensing and discretion to a prohibition with a specified purpose. Now, why am I using these 3 lines? It's prohibition with a specified purpose, protection of core activities. That theme does run through the codes. The codes are running in a direction where there is, to some extent, a noticeable line of reasoning. Now, what matters is what happens with the courts and how the courts and Honorable Justice Midha, who's passed these wonderful seminal judgments in PTI, Employees Union, and so on. If you go back, you'll be going back to the courts for implementation, and I'll show you there are still areas of doubt. Go to the next slide, please. So if you look at this, for example, there is provision in CLARA, that is the Contract Labour Act, for the principal employer to be liable to pay wages in full and the unpaid balance due whatever the contractor fails to do. Now go to the next slide and I'll show you that there's still a problem. Can you go to the next slide, please? Thank you. While this problem has been sort of brushed under the carpet, that they've maintained Section 21(4) in Section 55(3) of the code, there is a new provision which is a little worrisome. It says that whenever you have a contractor register, he is going to pay some kind of deposit. Okay, that's new. I didn't know that you'd pay a deposit and then get registration. Well, there's provision in the Act for this. And go to the next slide, please. And here you'll find that the deposit is covered under Section 47(1). And what level that deposit is going to be set will be quite an important game changer. Because that means that a contractor will have to, does he have to deposit all the wages of his employees for 1 month in case he defaults, and then he'll get a license? I'm not clear on that, but the rules will tell us. But there's some scope for worry there, because this is a new provision. I don't know, maybe Mr. Malik knows better than me, but I don't know the answer to that yet. Let's go to the next slide. Now, to my mind, what we suffered in the particular court that we went to and we defended and we won against a labor enforcement officer should never have happened, but it happened because of Section 23 of CLARA. CLARA covers you and sends you to a possible term of imprisonment for violation. Although the judges may not imprison the CEO of a big company for this kind of technical violation, it is too much of a risk. Now, by contrast, Section 94 imposes a more general penalty and does not talk about imprisonment in the first stage. So that's a good thing, though the penalties are high, as was mentioned. I think Mr. Pawan Mankotia had mentioned, the penalties are high. They are, especially for a small employer, that's not low. Let's go to the next slide, please.
Mr.
Sorry, should I be finishing?
If you please,
I'll wind up, sir. I'll just
we
wind
still
up.
have one more speaker. Yeah.
I'm so sorry. I'll move towards winding up. So there are the penalties mentioned. And if we go to the next slide, please. The difference in approach, to my mind, is that you're talking about fiscal penalties rather than putting people at the first instance in jail. And if you see section 114, which is a compounding of offenses, then the good news is you still have the possibility of compounding a provision that did not exist under CLARA. And one new thing has come in, which I'd like to say. And that is, if you don't commit the same offense within 3 years, then that compounding is there. It's only if you commit the same offense within 3 years that you risk going to jail. Thank you very much. Go to the next slide, please. And you will find that I have been as succinct as I could. That's the end.
Okay.
Thank you for your patience.
Thank you, Mr. Pasrich. I would now request Ms. Ritika Ganju to speak on managing remote work situations, which aspect, unfortunately, is missing from the labor codes which have been enacted.
Thank you, Mr. Vaseem. And as you correctly said, that there's no reference to the provision regarding work from home arrangement or remote working. That's why, unfortunately, I don't have a presentation, unlike my co-panelists. I will just quickly put out certain points from my experience regarding the existing legal regime and what I see in the new labor code, what could be added there, incorporated there to facilitate the new arrangement that many industries have adopted in pandemic times. Firstly, even though there is no express provision in the existing legislation, my understanding has always been that there was never an intention to exclude employees who are working from home from the purview of the employee welfare or benefit legislations. And that is how we have advised in the prior, pre-pandemic era to most of the IT companies that have come back to us with employment questions. But certainly, I feel the shortfall of specific provisions now, given that not just IT industry, many service sector have now shifted to this arrangement and may continue to work on this arrangement for a longer time. One thing that I see is that me and my colleagues never felt that there was something missing in the existing legal regime as far as work from home arrangement is concerned. But certainly a question for this panel probably to think about is there was complex situations that we were dealing with where one employee is the employee is in one state and the employer is in the other state. Now that becomes a complicated situation. It's not something relating to central legislation, but more to do with state laws such as shop and establishment. But the complex situation arose because there was no one uniform law that could have been followed. For example, if an employer is in Maharashtra and the employee is in Bangalore, so we were dealing with two state laws. And given that there was absence of any judgment or judicial precedent or any clarity from the regulators, we actually have practically advised our clients to give best of what is available to the employee. So that is certainly not being addressed even now, as Justice Midha pointed out, that this is something that the rules can actually look into. While the legislature draft those, this is something that can be looked into, because certainly the scenario will become more complex, given that retrenchment, layoff, closure may have to be dealt with more than one state while we're looking at work from home arrangement. Now, coming to the new labor code, to my mind, there's a lot that can be incorporated. And having said that, to my knowledge, there are countries like Poland, Netherlands, Chile, who have started to recognize the work from home arrangement. Of course, countries like UK, US already had recognized the arrangement and certain aspects related to work from home arrangement in the legislations. But countries such as India would now have to really think about putting certain points. So I would just like to touch upon these 3 or 4 points that I think from my experience, which could be incorporated. One is the duty of the employer. So as regards duty of employer is concerned, of course, one is that, the cost for operational setup, work from home setup, and the cost of operation out of home, that is something that has to be covered by the employer, that should be covered by the employer as a component of wage or, as a reimbursement. This is something that is could be a subject matter of the wage code, as was being discussed here earlier. Second is the duty of care. So our welfare legislations already have certain duty of care attributed to employer. To what extent that will be applicable in case the employee is working from home, that could be an interesting point of discussion, because certainly it can't be the same when the employee is working, in the premise of the employer. Expressions like personal injury, when we talk about ESI, and accident during the course of employment. So these expressions will have to be rethought, probably, because the same fact that what is the course of employment, what will be treated as, personal injury when the employee is working at his premise or a chosen premises, maybe not home, but at a chosen premise by him and not employer's premises. On a connecting point, as Mr. Mutneja also pointed out, he touched upon the definition of establishment. By way of an example, this is just an example, there could be more definitions that could be looked into in the new codes, whether they are wide enough to include employees who are working from home, or at least they confirm that, they are not excluded. So as Mr. Mutneja said that, the definition of establishment is wide enough, just a thought that it still refers or connotes to a place of trade or business. While we've seen that a lot of states shop and establishment, for example, Maharashtra, uses the definition of commercial establishment in a much broader sense. And there is a settled law that commercial establishment or establishment does not connote a fixed place of business, and therefore would include employees who are working from home. So just a thought that, it could be broadened. There's such definitions. Establishment is just an example, but we could look into other definitions also. And lastly, I'm keeping it really short. Lastly, I would just leave you all with the thought that what constitutes work from home? That is something, work from home, or as you said, remote working, teleworking, these are interchangeably used terms. What constitutes that? Would you say that employee working for a day or period of 1 year? What would constitute work from home, and therefore the benefits that will be attributed to work from home arrangement? To give you an example, in Spain, the latest notification after pandemic puts it as that for a reference period of 3 months, if an employee 30% of a working day, he's working from home or a premise chosen by him, it constitutes to be work from home. So this is something, these are some, few changes or yardsticks that we can discuss more probably, because it has never been discussed before. We can think about it to be incorporated in the new code to just facilitate this kind of arrangement, which definitely will be there for a long time. Thank you. That's all.
Thank you, Ms. Ritika. Dr. Lalit Bhasin may like to.
Yeah.
Yes.
I thank all the eminent panelists here, and also Justice J.R. Midha for his presence. At the end of this, I'm a bit confused whether it is old wine in new bottles or new wine in old bottles. And I'm literally confused, because what in my view has been done is the laws were already there. They have been tried to be put in one place. It is like a codification of different statutes into one code. Whether it is wages, the laws basically still remain the same. Whether it is minimum wages, some cosmetic changes have been made here and there, as was pointed out by Mr. Pasarich also, and also about the outsourcing. That aspect needs to be considered. What is the core activity? And core activities go even to period before the Contract Labor Act came in that. Supreme Court considered that in standard vacuum case, what is core activity. So we are in a way going back, you see, to the pre-Clara period. So these are the issues which need to be taken up. Whether these codes will create more confusion or they will really create a better environment to promote the growth of industry and commerce and business in the country. That is yet to be seen. But we had the benefit of these legislations which have stood the test of time and over which you see jurisprudence has been built up thanks to our Honorable Supreme Court and the High Courts. Now a fresh attempt will have to be made. So that is why I suggested earlier that this will not be the final word so far CII Legal Services Task Force and SILF is concerned. We want to continue this discussion in possibly another webinar or a series of webinars, taking up each code by itself, discussing, debating, and then move forward to the second code. Because yes, we had very good presentations on all the codes, but what are the implications vis-a-vis the existing laws which are still there till 1st April? And as I said earlier in my opening remarks, whether the jurisprudence which developed earlier would still remain relevant, I feel that would still remain relevant, but let that be discussed and debated upon. So I thank everyone. I thank the chair, Mr. Alok Bhasin, for this excellent webinar on a very, very important topic, which is of great importance to CII membership also. And Ritika also made an excellent presentation. I think you did a wonderful job without a proper slide PowerPoint presentation. That was very, very effective. Thanks a lot.
Thank you. Thank you so much, sir.
Over to you, Vikas, if you are still there, to just thank everyone.
Of course, of course. So thank you, Chairman, sir. And I think the message is quite clear that we need to have detailed, and we could have much more time because all the presentations were quite exhaustive and quite detailed, and the time was short, and there were some questions also being put by the participants which we couldn't take. So apologies for that. But the learning is that, as Chairman said, that there would be more sessions focusing on each of the codes and more deliberations. And as Honorable Justice Midha said, that on the rules, we will be doing forming a subgroup and then studying that and then making recommendations on that. So with this note, I would like to thank everyone for your time and sort of detailed presentations and your insights, which I am sure is a learning experience for all the participants. So thank you, Mr. Amir Pasarich, Honorable Justice Midha, Mr. Anupam Malik, Mr. Mutneja, Ritika, of course, Mr. Alok Bhasin for moderating this session, and to the chair, Bhasin, for guiding us for formatting this legal services month. Thank you all for your time. Thank you.
Thank you.
Thank you.
Thank you.